Good morning. Can you hear me?
Hello?
Yes, hi. What case are you here for this morning?
Christine Morgan, Metro Auto and Truck.
Oh, okay. Are you the plaintiff?
Yes.
Okay, I'll rename you.
Matthew Wilson's my attorney.
Okay, thank you.
You're welcome. Thank you.
Morning, Matt. Can you hear me?
Yes, George, good morning.
Good morning. That's all.
This is 2301211 GC. This is Christine Morgan versus Metro Auto and Truck Centers LLC. May I have your appearances, please?
Morning, Your Honor. Matthew Wilson on behalf of plaintiff Christine Morgan.
Good morning, Your Honor. George Serkin on behalf of defendant Metro Auto.
Thank you. Today is the day and time set for hearing on the defendant's motion for summary disposition pursuant to MCR 2.116C10. The court has received and reviewed the motion and its responses and the reply to the response. Mr. Wilson, please proceed, sir. I'm sorry. Mr. Serkian, please proceed.
Thank you, Your Honor. Your Honor, all I can add to my brief itself and my response is just a couple other remarks to the plaintiff's answer to our motion. First of all, the argument is that tools and equipment are interchangeable, but they are not interchangeable, Your Honor. There's a distinct difference, as I indicated in my pleadings. Tools belong to the mechanic. At the end of the day, they're put in his toolbox. If he changes employment, he takes his tools with him. The equipment belongs to the shop. That's heavy-duty equipment such as wheel balancing machines, hoists, and that type of thing. Now, the plaintiff claims that she owns that equipment by virtue of her being the manager of her late husband's business that purchased that equipment. Well, she has the option to still proceed with that equipment request. My client is not in a position to give her that equipment. When the rightful owners of the property took over the premises about a year and a half ago, they instructed him that he could not remove the equipment from the premises. Now, if she has a claim for that equipment, it's against the owner of the property, and her recourse is, Your Honor, that she could file an action in probate court and ask the probate court to give her possession of her late husband's business entity. And with that business entity, then she can make a claim for that equipment. So where we're at, Your Honor, without beating this thing to death, is that the tools have been sent. Even after her husband's passing, when my client took her husband's tools and put them in his tool chest and locked them up, because he had other employees coming in there and working for him, he didn't want her husband's tools to be missing. So those tools were secured from day one. And even as far back as December, after this case started, I had informed Brother Counsel that they could pick up the tools. Finally, the tools were picked up on April 24th. So the complaint itself, Your Honor, asks for tools valued at $18,000. Those tools have been received. Now, the plaintiff doesn't want to stop this matter because the plaintiff during her depositions claimed, oh no, there's more stuff, and that stuff consists of equipment, which is worth $10,000. Now, the plaintiff says in his response, well, perhaps we can turn around and amend the complaint. Well, if that's the case, Your Honor, then they should have asked for $28,000 right from the start. They should have asked for the $18,000 in tools. They should have asked for $10,000 in equipment. And this case would not have been in a district court. This case would have then been in a circuit court. But now they want to take this case in segments. All right, they got their $18,000 worth of tools, but now they want to continue it by seeking $10,000 worth of equipment. My client does not own that equipment. He has no authority to give her that equipment. That equipment is under the control of the property owner. If she wants to make a claim on that equipment, she can make it against the property owner. If the property owner will not recognize her claim, then she can file a probate court. Simply having receipts that her husband's business had, and simply because she was the manager of her husband's business, doesn't give her ownership, Your Honor. That equipment was owned by her husband's business. And she has a recourse, as I indicated, to file an action in probate court, have the probate court give her authority and ownership of that LLC that her husband owned, thereby she can make a claim for the equipment. My client has did what he was supposed to do. He turned that equipment, that tools over to her on April 24th. As a matter of fact, they were placed in a truck that belonged to her husband that stayed on the premises. My client even turned around and took care of the truck and got it working again. And her son drove the truck off with the tools inside. So, Your Honor, I respectfully submit this case has been settled. The plaintiff asked for $18,000 worth of tools, which she received. She is now seeking more equipment, which my client has no authority over, does not own, and there's a recourse for her to seek that equipment if she wants, as indicated. Thank you, Your Honor.
Thank you, sir. Mr. Wilson.
Morning, Your Honor. Yes, our position is there is no distinction between tools and equipment, that it's an artificial distinction. What we are seeking is the property that was owned by my client's late husband. Defendants acknowledged part of that, right, in turning over that truck that had his tools in it, but there's additional tools there. And this valuation of $18,000, I'm not sure where that's coming from, that they've turned over $18,000 worth of equipment that were in the wrong court. That's all sort of news to me here. We just want what my client's late husband owned that is being used by defendant in his shop. So he has turned over part of that, and it's much appreciated, but there's additional items there. And to say that they're equipment and not tools is just a red herring. It's an artificial distinction that especially for purposes of this motion shouldn't cause my client's action to be dismissed. This was brought under Rule 2116 C10, which tests the factual basis of the claims. Facts should be presumed in favor of the non-moving party, which is my client. And if if these items should have been called equipment, then we should be able to amend the complaint then, because it's a distinction that is sort of, arbitrary, right? To us, everything is a tool. It's being used in the shop by the defendant. As far as whether or not there is a alternative in probate court, this is an LLC, right? LLCs don't need to be probated. My client is acting as the manager of the owner of these tools or equipment or whatever you want to call them, and that's the factual basis for a claim. That's what's being challenged here, that there is no factual basis for the claim. She's presented the receipts as owner as the business being the owner of the property. She's the manager of the business. She's entitled to them. And the defendant is the one using the tools every day. If there's someone else that owns them, then he should, turn to that person for relief. So, that's our response, Your Honor.
Your Honor, if I may.
Thank you. Wait 1 second. Mr. Wilson,
Awesome.
before Mr. Serkian responds, I had 2 quick questions. What is your response to Mr. Serkian's suggestion that the Bumstead should be added as necessary parties because what remains are fixtures?
There's no evidence that they're fixtures, Your Honor. These are tools used in the shop, right? I mean, fixtures are, and if they are fixtures, that's a question of fact, and it shouldn't be dismissed as a under C10, right? To my knowledge, it's a question of fact. Do these things have wheels? How are they used? Fixtures are part of the real estate. Is this part of the real estate? I don't think so. Possibly they are, right? But that's a question of fact, I guess, that would have to be determined as to, if it is a fixture, then okay, got it. The owner of the real estate is the owner of it. But these are, tools that were brought into the shop and used as part of the repair process, so they can be taken out.
That was number 1. And then number 2, discovery in this case opened back in December of 2023. And there was nothing in the complaint that itemized what the items were that were being requested. And if as defendant asserts, the original claim was for $18,000 some odd dollars, and then there were property turned back over to Ms. Morgan within the last month or so, what's the allegation of what remains due and owing?
It's the $10,000 worth of that's remaining that hasn't been turned over, right? So I'm not sure if that answers your question, though.
Are you talking about the aligner, the lift, and that other?
Yes, Your Honor.
The receipt of what the other thing was.
Yes.
And your suggestion, ma'am, you can stop nodding. It's not helping.
I'm sorry.
Is it your suggestion that the aligner, the lift, and whatever the other thing are not affixed to the building or the property, that these are easily pick up, things easy for her or someone else to pick up, retrieve, and remove? They're not affixed to the building or the floor or the ceiling in any way, shape, or form?
I'm not sure, Your Honor. So, I mean, that's
Okay.
why it's a question of fact. I believe some of them have wheels, but
They were put in, they can be taken out.
Ma'am, no one
sorry.
asked you to respond. Mr. Wilson, sorry.
I'm not certain, Your Honor, if they're how they're in the building. To my knowledge, an alignment machine has wheels, as does an engine hoist. But these could be different. I'm not sure. So I think that speaks to my point that it's a question of fact. Are they fixtures or not? We can't, say today that they are fixtures unless, brother counsel has some, insight into that. But
Okay.
Thank you. Mr. Wilson, I was asking because when I look at the nature of a C10 and the allegations that there have been certain properties that have already been returned, it sounds like there remains very narrow issues between the parties. I'm just trying to figure out from your conversations with one another, since the case was filed back in September of 23, more specifically where we are. I know this case was originally on track for jury trial, but I'm hearing the motion and I'm trying to figure out where we are, what issues truly remain. Mr. Serkian, did you have some response to Mr. Wilson?
Yes, Your Honor. With respect to the $18,000 figure that Brother Counsel said he doesn't know where they came from, that was in their complaint, Your Honor. They said the tools were valued at $18,000. The tools were returned. I respectfully submit, Your Honor, there is a distinct difference between tools and equipment. The equipment is part of the shop. The equipment is always found in shops where automotive mechanics work. That consists of wheel balancing machines, lifts, hoists, and other things, which are equipment, Your Honor. Well, it's specious to turn around and say the equipment is a tool. It's not a tool. When a mechanic leaves the shop, Your Honor, he doesn't take the wheel balancing machines. He doesn't take the hoists. He doesn't take the lifts. Those items stay in the shop. And that's what we're arguing about today. The plaintiff seems to think that my client has the authority to take that equipment out of the shop and return it to her, and he does not. Now, the complaint sought $18,000 worth of tools in their own words, and the $18,000 worth of tools were returned. As far as the defendant is concerned, Your Honor, the complaint has been fully satisfied. The complaint has been fully satisfied. This matter should not go further. If Mrs. Morgan has an argument and a claim for the equipment, then she can proceed against the Bumstead family. The Bumstead family that rightfully took possession of the property after it was found that Mrs. Morgan did not have rightful possession of the property, has instructed my client that he cannot remove those tools, that equipment. So if she wants to go and proceed against the equipment, she can proceed against the owners of the property. She proceeded against my client for the return of $18,000 worth of tools, and $18,000 worth of tools were delivered to her on April 24th. That is my response to Brother Counsel's argument, Your Honor.
So if I may respond, Your Honor, just briefly.
Yes,
So,
sir.
In terms of $18,000, that's the total amount. What was returned, was tools in the trucks. There's $10,000 remaining, and I think in answering the question, Brother Counsel just answered the question of whether or not these are fixtures, right? His response was that the equipment stays with the shop. So to the extent the Bumsteads aren't the owner of the shop, they're the owner of the real estate. And so the defendant is the one who operates the shop here. Then, according to that train of logic, then he's the owner, right? And we are suing the right person. So, and I just go back to the fact that under this, the fact that there may be an alternate party shouldn't, under a motion for dismissal under C10, our action shouldn't be dismissed because there's potentially another party. That's not a basis to dismiss the action.
Your Honor, whether we
not
call
a I'm sorry, one second. If not a dismissal, Mr. Wilson, you started your response to Mr. Serkian by saying there's the issue of $10,000 remaining. At the end of the day, this is just about the value of the alleged equipment. Why aren't we just getting to a hearing as to the amount of damages that remain due to the plaintiff? Summary judgment in part for the defendant.
I'm not following that, Your Honor. So a summary judgment in part, except
if you filed a case, if plaintiff filed a case for $18,000 for the value of tools and equipment, and there's nothing in the complaint that specifies what the tools are, what the equipment is, and what the value of it is. And there's now an acknowledgement that sometime in the last month or 6 weeks, there was some property returned to the plaintiff. The only issue that remains is the amount
the property
of money that might be due. Okay, go ahead.
I'm just gonna say, so the property that is still under dispute hasn't been returned. So those 3 items that we had presented receipts for were not returned. There was separate tools that were returned. So
Okay, So
Your Honor, if I may.
your response to his motion attached those 3 invoices. And I guess if the court asked the question more clearly, if your position is that the only remaining property to be returned to Ms. Morgan are the 3 items identified in these receipts,
That's right.
the only question that remains would be the value of those items, correct?
And well, I think council is disputing whether or not they should be returned. Right?
Your
So-
Honor, if I may, as far as the value of those items, Your Honor, we can go on all day and all night on the value because those items were purchased approximately 8 or 9 years ago, Your Honor, number one. Number two, the plaintiff had every opportunity to include the $10,000 worth of equipment along with the $18,000 worth of tools, which would have made her demand $28,000. And as I indicated, Your Honor, if this complaint was properly filed, seeking $18,000 worth of tools and $10,000 worth of equipment, it should have been filed in the circuit court because of the limits of the district court of $25,000, as you're well aware. Now, we have satisfied the complaint itself, Your Honor. The complaint turns around and says, well, now there's more stuff. The plaintiff says there's more stuff. That stuff, Your Honor, is used equipment, which was purchased by her late husband's business, not by her, not by her husband, but by her husband's business. Simply having receipts of that business doesn't give her ownership of that equipment, Your Honor. If that's the case, Your Honor, then people don't have to go to probate court to turn around and ask for relief on items and just present receipts and say, well, here's a receipt. I own it now because I have the receipt. Now, the receipt was made out to her late husband's business, Your Honor. She doesn't have ownership of that equipment simply because she was the manager. That equipment was owned by her late husband's business, and she does have the authority to take control and ownership of her late husband's business, which would then give her ownership of that equipment, Your Honor. So we have done our part, Your Honor. The complaint asked for $18,000 worth of tools. It was delivered. As a matter of fact, also his truck was there, which was left in the premises. That was delivered. So arguably you could even say more than $18,000 was delivered to the plaintiff because she received her $18,000 worth of tools plus her husband's truck. So all I can say is, Your Honor, my client does not have any authority or ownership over that equipment. And even if the court or anybody was to claim that it belonged to Mrs. Morgan, he's caught between the rock and the hard place, Your Honor. The property owner who took control of the building and the equipment therein is the owner of the property, Your Honor. That equipment was in the property. Now, she could have proceeded a long time ago if she thought she was wrongfully evicted, but she was not. She claimed, Your Honor, that she owned that property back when her husband died. My client paid her $2,400 a month for rent for over 13 months. And during her deposition, Your Honor, she claimed that, oh, no, he wasn't paying me rent. He was paying me for rental of the tools. Mechanics don't rent tools, Your Honor. They buy their own tools. I submit that the plaintiff does not come into court with clean hands, Your Honor. She claimed from the beginning that she owned the property. When it came to pass that she did not own the property and the Bumsteads took over the property, then she changed her story and said, oh, no, he wasn't renting the property. He was renting my husband's tools. Mechanics don't rent tools, Your Honor. If he paid her over $24,000, he paid more than the value of the tools in alleged rent, Your Honor. So she has been made out quite well in this matter, Your Honor. She's received $24,000 that she never should have received. And if she claims she should have received that, when the Bumsteads came and took over the property, then she should have turned around and filed an action against the Bumsteads, but she did not. She had filed an action in the Wayne Circuit Court seeking ownership of the property, and that case was dismissed, Your Honor, because she could not prove her claim. So she tells my client without telling him about the Wayne Circuit Court action. She owns the property. He pays her rent for over 13 months at $2,400 a month. Now that that's stopped, now she wants to turn around and get $18,000 worth of tools, $10,000 worth of equipment. She's received the $18,000 worth of tools, Your Honor. And the $10,000 worth of equipment doesn't belong to my client. It's under the control of the Bumstead family. And if she wants that equipment, she should go after them, Your Honor. The proper way, as I indicated, through a proper probate court proceeding, which would give her rightful ownership of her late husband's business. Her late husband's business is the owner of that equipment, Your Honor. And that way she would have access to her late husband's equipment. Thank you.
You know, the value of the tools that were returned, our position was not $18,000. I think brother counsel's arguing that
What receipt do you have for the tools?
Hold on 1 second, sir. Mr. Wilson.
So there was a truck of tools that are not, Mr. Serkian's arguing that $18,000 worth of tools were returned without any evidence for the value of the tools. It was a truck of tools. So our estimate when we filed the complaint was the total of everything was $18,000. So it's this $10,000 that we have receipts for that haven't been returned, plus this truck of used tools. And so the complaint hasn't been satisfied. That $18,000 amount hasn't been satisfied. Counsel's arguments is going both ways. He's saying the Bumsteads are owners of the property that's still in question, the equipment or tools, whatever you want to call it. And then now he just says the Morgan, her husband's business was the owner, and we should file a probate estate for those tools. It was an LLC, right? She's the manager of the LLC. She's acting as the manager of the LLC. There's no reason to probate this case, right? What probate is for when somebody dies. The owner of the tools was the LLC. The LLC continues. So she has, at a minimum, established enough factual ownership of this property that remains in question to survive this C-10 motion.
Your Honor, her late husband.
I'm sorry.
Her late husband.
I'm sorry,
owned the
Mr.
LLC.
Wilson. So hold on 1 second. Mr. Wilson, and you alleged this in your response to the motion. Your allegation is because she's the manager of an LLC that she has a right to claim the property of the LLC?
That's right. Yes. So
Then I guess I would expect the case to have been brought in the name of the LLC.
Right.
I'm a judge in this courthouse. I claim no ownership interest in any piece of property in here. That's an aside, Mr. Wilson. That's not really a question. I was just curious when I read it in your response. Mr. Serkin, were you saying something else, sir?
All I was saying, Your Honor, as manager of the LLC, and many, many businesses have managers, managers don't automatically own the assets of the LLC. She was the manager of the LLC. Her late husband was the owner of the LLC. He's the one that established the LLC. And all she was the manager of record. Managers of record do not own properties that belong to the LLC, Your Honor. So if they have an action, it's against the LLC or on behalf of the LLC. And if they want to proceed on behalf of the LLC, they would have to proceed against the property that's held by the Bumsteads at this particular time, Your Honor. I think that clarifies that point to the best I can, Your Honor. Thank you.
Thank you. The court, again, has reviewed the motion, the response to the motion, the reply to the response, and took the opportunity to review the other documents that had been previously filed. The court notes that the sole allegation, the complaint, is conversion. And after having a chance to read the motion for summary, the response and reply, the court will concur with Mr. Wilson, the plaintiff, and find that there are issues of fact beyond the amount of damages that might be due to the plaintiff in this matter. Both parties in their argument have raised issues about the ownership of the remaining 3 items, the the proper venue to pursue recovery of either the actual three pieces or recover the value of the three pieces. That's an inartful way of saying there remain questions of fact in this matter beyond the amount of damages that might be due to the plaintiff. The court will deny the defendant's motion for summary disposition. Noting that the return of the property and the work truck, whether it was a month ago or 6 weeks ago, changes, the court believes it changes the posture of the case and the value of the case. And my question then to you, gentlemen, would be how to best proceed. I know there had been requests for jury demand, and we had originally adjourned the jury trial to have this, well, canceled the jury trial to have this motion heard. And the conversation at our conference was, if a jury date was needed, we would pick it today. That being said, do you gentlemen need a moment to speak, or are you ready to proceed to schedule a jury trial? Is jury trial still demanded? Do you need a moment, or are you ready to pick a date?
Yeah, I'd like to talk to Mr. Serkian if he's willing to do so.
Okay, I have an arraignment that might start shortly, but Marianne will move you into a breakout room. If we start the arraignment, I'll be right back to you. Otherwise, we'll resume in just a moment. Good morning, Mr. Kaplan.
Good morning, Your Honor.
We're expecting Van Buren to come right out.
I'm not sure if they, he was getting the officer when I came back in. I don't know if you guys can bring him.
They just popped back in.
Okay.
This is State of Michigan versus LaJean Marie Banks. These are 190896 FD 200354 SM 230007 FD 240405 FD and 240422 ST. Your appearances, please.
Your Honor, Joshua Kaplan on behalf of Mr. Banks.
State your name for me, sir. I'm sorry.
LaJean Banks.
Thank you, Mr. Banks. Today is the day and time scheduled for the arraignments in these matters. Mr. Kaplan,
Yes, we're gonna waive a formal reading and stand mute to the charges, Your Honor.
thank you. Mr. Banks, you have an absolute right to be represented by an attorney in these felony matters. If you're unable to retain an attorney through your own resources or that in friends and family, the court is able to provide one for you. Attached to the front of your files was a request for a court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Kaplan. It will be another attorney that relies on the information contained on this form to be in contact or communication with you. Sir, you also have a right to be considered for pretrial release. In this case, with Mr. Kaplan, I don't know if it's better to take them one at a time or not. The oldest of the case is the 2019 case. The bond request is for cash bond based on Mr. Banks' failures to appear, his outstanding warrants, and his additional felony warrants. Your comment as to bond.
Yes, Your Honor. I don't know if you want to take them all because my comments on bond are going to be all the same. But with regards to bond, he's currently laid off as a construction worker. He knows that he has a case coming up with Judge Green. He mentioned that to me. So he is knowledgeable. He does want to take care of these. He lives with his mom, takes care of his daughter and grandson. His biggest reason that we're hoping to actually get a personal bond on this, and I know his criminal history is not great for that, but the reason why, he's got some serious health concerns. He has sleep apnea. He needs his CPAP machine. He's got serious high blood pressure and heart issues. About a month ago, from what he told me, he had actually been picked up on this, had to be emergency rushed to the hospital. So that's why he was not arraigned a month ago, and spent a week in the hospital before finally being released and going home to recover. He doesn't have an ability to pay a cash bond at this time. And looking at some of the cases, I know one of the cases, 240405, was actually from April 11th of 2022. It didn't get entered into the system and charged until May 1st of this year, 2024. Given his health issues, we would be requesting a personal bond.
Thank you, Mr. Kaplan. Mr. Kaplan, based on Mr. Banks' criminal history that goes back more than 20 years and his failure to appear repeatedly in this case, in this court will set Mr. Banks' bond at $5,000, 10%. He is not to be released without alcohol tether. In the case that ends 896007 and 405. The most recent case, the 422 case, is the forged license. The rest of them will require alcohol tether. Mr. Banks, your next appearance dates will be June the 12th, 2024 with Judge Green by Zoom at 9:45 a.m. For the felony cases, those will be probable cause conferences. For the misdemeanor cases, those will be pretrials. Again, these are case numbers 190896, 200354 SM, 230007 FD, 240405 FD, and 240422 ST. Again, pretrial or probable cause conference, all scheduled with Judge Green on Wednesday, June the 12th
You heard
at
me?
9:45 a.m. In the assault and battery case, the 354 case, condition of your bond, sir, is that you have no contact with the complainant in this case. That being Dolores Banks. Is there anything else, Mr. Kaplan?
No, Your Honor. Well, yeah, the only thing I would request, and I don't know if, but he wanted me to put on the record with you, his biggest concern is getting his medications. He hasn't been able to take them since yesterday, and he's concerned for his health on that. I know there's only so much you could do. It's more working with Wayne County Jail, but that is the concern.
Thank you. And Mr. Kaplan, I thought that they did a screening when Van Buren turned him over to the county, that they did a medical screening and would take a list of his medications. Unless you're suggesting I don't know how they do it, but I thought that was how they did it.
I know personally, he's just concerned with the transfer to Wayne County, assuming that that's what he's going to be doing. He's very concerned about getting his medication. He hasn't taken them since yesterday, and I've personally had to go there with clients' medication before and fight to get them to my client. It can take a little while. So that was his concern.
Before we conclude, the recommendation for the cash bond signed by Van Buren was just signed this morning. Unless there's been some change and they have no objection to a personal bond with the alcohol tether, I mean, he still would have a delay of having that tether installed. Van Buren, do you have any insight or requests at this time?
Well, additionally, he's got an additional case out of Wayne County for OWI. So nonetheless, he would be going down to Wayne County.
Thank you. Thank you for your concern, Mr. Kaplan. We'll note it on our end. Is there anything else, Van Buren?
No, Your Honor.
Thank you. Good luck to you, Mr. Banks.
Thank you.
Mackenzie, I'll get your files noted and down to you as quickly as possible.
Sounds good.
Thank you. We're back on the record in 2301211 GC Morgan versus Metro Auto. The parties have returned from the breakout. Gentlemen, was there some update?
Yeah, yes, Your Honor, thank you. We have discussed some of the issues. I think we need to talk to our clients about some potential here.
Charlene,
So I don't know what in terms of,
am I muted here? What's going on? Can you?
No, I can hear you, sir. I can hear you.
I don't think he can hear us as maybe.
Must be.
I don't see anything.
Oh, his volume might be turned down because everything else is connected. Are you able to hear me, Mr. Serkian?
Wait a minute.
Click on you and see if that helps anything.
Ma'am?
It's recording and it shouldn't be recording, I don't think.
Oh, here.
Were you okay in the breakout
Audio.
room with him, Mr. Wilson?
There was a bit of a,
They're on mute.
at first he couldn't hear me either, and then suddenly he could.
I want to keep talking so that when they are able to get their volume adjusted, that they know that we're good to go.
Can you hear me now, Judge?
Yes,
can hear
sir. Can you hear me?
Still recording.
Wait a minute.
If his chat were open, maybe a suggestion that he turn his audio up. I'm wondering if that is the issue. Possibly. You never know. Some people are better at this than others.
It's something to do with your audio right here.
Yes, maybe the volume just needs to come up a little bit.
Your space.
Oh, did
I don't see
Mackenzie
unmute
leave?
down here. Usually unmute comes down there.
Sir, are you able to hear me now?
Back to
We're
your
able to hear
audio.
you. Mary Ann, here's the question. If you said cash
We'll see
bonds
if I
in
can
3
get
files,
Ezra. Maybe he
Let
can.
let me see if he's there.
Okay, he could.
I'm wondering if one cash bond is sufficient. Do not release without alcohol. Tap the screen for now.
You mean to not write it in everyone?
No. I'm writing it in every one, but if you said cash bond in all the files, then that you're talking about posting $2,500 versus you're not gonna be
He said
released
host would like
without
you to unmute.
Mr.
setting a
Wetzel, can I
cash
put you on
in the
hold for one
most,
moment?
in
Sorry, I
the
have
oldest of
something
files, I think
urgent
is what
coming.
we're
I'm
doing.
going off the clock here. Okay, what's going
How
on?
do I get back on there? It said unmute, but unmute doesn't show up there.
Oh, because you're not connected to the audio. Hold on. Let's try. Hi, can you hear me?
Yes.
Yes, sir. I'm able to hear you. Wonderful. Thank you.
Okay, there you go, George.
Thank you.
Thank you. Mr. Wilson was starting to say that there had been some conversation and he was about to explain the nature of the conversation, or as much as possible, I think.
That's correct, Your Honor.
Yeah, so I think I need to talk to my client about some potential development in the case.
Did she leave?
Looks,
Oh, no. Do you want to go into a breakout room with her? Or is it
No, Your
longer
Honor,
than a breakout room
if I may.
conversation?
Your Honor, if I may.
Yes,
I
sir.
need some time with my client to discuss this. I can't do it this morning, Your Honor. Could we just perhaps adjourn this for a couple of weeks? And
What's a couple?
Mr. Wilson has made a suggestion that I think might work, Your Honor, but I need time to discuss this with my client. And he needs time to review it himself.
What's a couple, Mr. Wilson? What's a couple of weeks?
boy, I think shorter is probably better. I don't think it's something that requires a tremendous amount of discussion.
All
I
right,
think
fine.
there's a, so what remains, Your Honor, just so everyone's clear, we need to pick a trial date. Is that right?
Let's pick a trial date and we can still proceed to try to settle this, all right?
Yeah, that makes sense to me.
Yeah, let's go ahead with a trial date, but we will still try to settle it. Go ahead. Thank you.
Here's the thing, and here's the issue that we had right before the original trial date. It takes 3 weeks to summon a jury in this building. Because we only have 1 jury assembly room and 2 jury deliberations rooms, I try to be mindful of not scheduling when other judges are scheduled. What I can do, if you gentlemen believe that you are close to resolving your issues, whatever that might look like, I'm happy to put you on as a second trial, secondary to an existing jury trial date.
Okay,
That's fine.
yeah, that's
That's
good.
fine.
Okay, that puts us on, Mary Ann, that Friday trial, Friday, June the 28th.
Yes, ma'am.
Would you want, do you need to come back before then? Or do you just want the jury trial date to be your next date?
I don't know
Let's
that
just
we need
hold
to
that-
come.
Go ahead. What was that, Matt? Go ahead.
I was gonna say, I don't think we need to come back. I think.
I agree. I agree.
Then I'll set your jury trial for Friday, June the 28th, 2024 at 9 a.m. Again, there's a criminal trial that is scheduled, criminal jury trial that's scheduled for that date. Your trial will be secondary to that trial. If for some reason you resolve this matter or you need to get back on before that date, reach out to Mary Ann. If the criminal trial resolves itself, we will confirm with you that that is still a date that you need. And I'm looking to see if we ever received the jury instructions and the witness and exhibit list from you. I don't have that.
We
part
need
of
to
the
submit
file
that,
with
Your Honor.
me.
Yeah.
Okay. Was there anything else, Mr. Wilson?
And not for me, Your Honor. Thank you.
Anything else, Mr. Serkin?
This time, Your Honor. Thank you.
Thank you. I'll see you on the 28th. Have a good afternoon.
Yes, ma'am.
Bye.